Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. The divorce attorney industry involves complex regulations that vary significantly by state and individual circumstances. While we utilize historical trends and statistical data to provide a comprehensive analysis, these figures do not predict specific outcomes for any individual case. Viewers are strongly advised to conduct their own due diligence and consult with a licensed professional before making any legal or financial decisions regarding matrimonial matters. Behind the closed doors of the American legal system sits a $4.5 billion machine that thrives when relationships fail. While many see divorce as a purely emotional tragedy, for a massive sector of the U.S. economy, it is a high-stakes business fueled by a refined divorce rate that sees approximately 14.2 women divorcing per every 1,000 married women each year. But here is the shocking reality that most people miss. We are currently witnessing a massive redistribution of wealth within this industry. In 2025, mid-sized law firms saw a 5% surge in demand, while the most prestigious elite firms struggled to hit even 2%. Why? Because the cost of ending a marriage has reached a breaking point. With the average contested divorce now swinging between $8,000 and $25,000, and high-asset cases easily clearing the $100,000 mark, the American public is no longer just looking for a lawyer. They are looking for a strategic exit from a system that seems designed to drain their bank accounts. In this video, we are opening the black box of the divorce attorney industry. We are going to analyze the historical trends that led to these skyrocketing fees, the states where litigation costs the most, and the emerging AI technologies that are threatening to dismantle the traditional hourly billing model. If you have ever wondered why some divorces cost the price of a luxury sedan, while others cost as much as a suburban home, you are about to find out exactly how the math works. This deep dive is designed to solve one primary problem: the information asymmetry between the legal industry and the American consumer. By the end of this masterclass, you will understand the economic levers that drive attorney behavior, the statistical likelihood of specific case outcomes based on regional data, and how to navigate the financial landscape of family law without becoming another statistic in a firm's profit margin. We are moving past the emotions and looking strictly at the data to show you how the business of heartbreak actually functions in the United States today. To understand the current state of the market, we must first look at the sheer volume of activity. The divorce service market in the U.S. was valued at approximately $4.35 billion in 2024, and is projected to climb to $6.2 billion by 2035. This represents a steady compound annual growth rate of 3.3%. This growth isn't just about more people getting divorced. In fact, the divorce rate has shown relative stability and even slight declines in certain demographics over the last decade. The revenue growth is actually driven by the increasing complexity of modern assets. We are no longer just talking about who gets the house and the car. We are looking at the division of cryptocurrency portfolios, complex stock options, and the valuation of remote work-enabled businesses. This complexity requires more billable hours, more specialized experts, and more legal maneuvering. Let's break down the actual cost of entry. In 2025, the average hourly rate for a divorce attorney in the United States typically ranges between $300 and $500. However, the average is a deceptive metric because the geographic variation is staggering. If you are filing for divorce in a high cost of living state like New Jersey or New York, you might see retainers, the upfront payment required to secure a lawyer, starting at $5,000 or higher. In contrast, in states with lower overhead costs, that retainer might sit closer to $2,500. This retainer is not a flat fee. It is essentially a down payment that is placed into a trust account, which the attorney bills against as work is performed. When that account hits a certain threshold, often called a replenishment trigger, the client must add more funds. This is where the financial open loop begins for many Americans. The industry categorizes cases into three primary buckets: uncontested, contested, and high conflict/high asset. Uncontested divorces. These are the industry's low-margin, high-volume products. In 2025, an uncontested divorce typically costs between $2,500 and $6,000. In these scenarios, the parties agree on the division of assets and custody before the lawyers are even fully engaged. The attorney's role is primarily administrative, drafting the settlement agreement and ensuring it meets state-specific statutory requirements. Contested divorces. This is the bread and butter of the industry. When there is a dispute over even one major issue like alimony or a specific visitation schedule, the cost jumps to an average of $11,300, but frequently scales to $25,000. High asset cases. This is where the statistics become truly extreme. For cases involving significant wealth or intense custody battles, costs can exceed $100,000. At this level, the attorney is just one part of a larger team that includes forensic accountants, child psychologists, and vocational experts. What is driving these costs higher in 2026? It is a two-front war on the law firm's expense structure. First, technology spending within legal services exploded by nearly 10% in the last year. Firms are investing heavily in e-discovery tools and secure client portals. Second, lawyer salaries have increased by approximately 8.2% over 2024 levels to keep up with inflation and the demand for top-tier talent. These costs are invariably passed down to the consumer. However, there is a counter-trend emerging. We are seeing a significant shift toward unbundled legal services. This is a historical shift in the industry's business model. Instead of hiring a lawyer for full representation, meaning they handle every email, every phone call, and every filing, clients are increasingly opting for limited scope representation. They might pay an attorney $500 to review a specific contract or $1,000 to represent them in a single mediation session. This a la carte model is the industry's response to a consumer base that is increasingly price-sensitive and technologically savvy. When we look at the regional data, the divorce belt of the United States offers fascinating statistical insights. States like Oklahoma and Nevada consistently report some of the highest divorce rates, with Oklahoma reaching roughly 20.7 divorces per 1,000 married women. Conversely, the Northeast generally exhibits the lowest rates, with Maine sitting at the bottom of the list at just 10.0 per 1,000. This geographic disparity creates a varied market for legal services. In high-volume states, you see a more competitive market with more flat-fee options and high-speed divorce mills. In low-volume, high-wealth states, the market is dominated by boutique firms that focus on high-touch, high-cost litigation. The impact of gray divorce among those aged 50 and older, is another critical factor in this statistical analysis. This demographic now represents a significant portion of the industry's revenue growth because these cases almost always involve accumulated wealth, pension divisions, and complex real estate holdings. Unlike younger couples who may have more debt than assets, the 50-plus demographic provides the legal industry with long-term, complex litigation opportunities that are less sensitive to immediate economic downturns. As we move deeper into this analysis, we have to address the AI elephant in the room. In 2025, platforms began delivering AI-assisted interview workflows and automated document generation that can streamline both DIY and attorney-assisted processes. This technology is effectively lowering the barrier to entry for the average American, but it is also creating a survival of the fittest environment for law firms. The firms that thrive beyond 2026 will be those that move away from hourly maximization and toward pricing models that align with the actual value delivered to the client. We have now set the stage. A multi-billion-dollar industry at a crossroads, where traditional high-cost litigation is meeting a new era of technological disruption and consumer pushback. We've seen the numbers, we've identified the costs, and we've mapped out the geographic landscape. But to truly understand how this affects you, we need to look at the specific tactics used within these cases, and how the business of law can sometimes conflict with the justice of the outcome. In the next part of this deep dive, we will analyze the specific billable hour traps and how historical data can help you predict the length and cost of your own potential legal journey. To understand the true mechanics of the divorce attorney industry, we have to look at the engine that drives it, the billable hour. This is the primary revenue model for the vast majority of the approximately 440,000 family law professionals practicing in the United States in 2026. While it seems straightforward on the surface, the statistical reality of how these hours accumulate is what creates the massive variance in final invoices. Imagine a typical client in 2026. Let's call him Mark. Mark lives in a mid-sized American city and is entering a contested divorce involving a suburban home and 2 retirement accounts. Mark's attorney charges $400 per hour, which is the current median rate for an experienced practitioner in a metropolitan area. In a traditional billable model, Mark is not just paying for the time the attorney spends sitting across from him in an office. He is being billed in increments, typically 6-minute blocks, for every microaction taken on his file. This includes reading an email from opposing counsel, which might take 3 minutes but is rounded up to the nearest 6-minute increment. It includes the 4-minute phone call to the court clerk to check a hearing date. When you multiply these tiny increments across a case that lasts an average of 12 to 18 months, you begin to see how the historical trend of escalating legal costs manifests. Statistical data from 2025 indicates that in a standard contested divorce, roughly 60% of the total billable time is spent on discovery, the formal process of exchanging information. Discovery is the phase where the industry's profitability often peaks. It involves the drafting of interrogatories, which are written questions, and requests for production of documents. For Mark, this means his attorney spends 10 hours reviewing 5 years of bank statements to look for inconsistencies. That single task costs Mark $4,000. If the opposing spouse is uncooperative or provides disorganized records, the attorney may spend an additional 5 hours drafting a motion to compel, adding another $2,000 to the bill. This is why historical trends show that the most expensive divorces are not necessarily the ones with the most assets, but rather the ones with the most friction during the document exchange phase. We must also analyze the role of the paralegal and the associate. In 2026, most mid to large family law firms utilize a tiered billing structure. While the lead partner might bill at $600 per hour, a junior associate might bill at $300, and a paralegal at $150. From a business efficiency standpoint, this allows the firm to maximize output. However, for the consumer, it can lead to double billing scenarios that are perfectly legal, but statistically significant in their impact on the final cost. For example, if both the partner and the associate attend a strategy meeting or a settlement conference, the client is often billed for both individuals' time. Historical case studies show that these multi-attorney meetings can inflate a single day's legal fees by 50 to 100%, without necessarily doubling the progress made on the case. Now let's look at the litigation escalation phenomenon. This is a behavioral trend observed by industry analysts where the cost of the divorce begins to outpace the value of the assets being fought over. Imagine if Mark and his spouse are arguing over a specific piece of artwork valued at $5,000. If the attorneys spend 10 billable hours each debating the valuation and the right of possession for this item, the combined legal fees of $8,000 have already exceeded the total value of the asset. This is a frequent statistical outcome in high-conflict cases. Data suggests that in approximately 15% of litigated divorces, the total legal fees eventually consume more than 25% of the couple's net worth. To navigate this, many 2026 firms are adopting legal project management software. This software uses historical data from thousands of previous cases to predict how many hours a specific type of motion or filing should take. If a firm's data shows that a standard temporary orders hearing usually takes 6 hours of preparation and 4 hours of court time, the software flags instances where an attorney spends 20 hours on the same task. This move toward data-driven accountability is a direct response to the growing public demand for transparency in an industry that has historically been opaque about its time tracking. Step by step, the life cycle of these costs follows a predictable trajectory. First is the initial consultation and retainer, where the client pays an upfront sum based on the anticipated complexity. Second is the pleading phase, where the petition and response are filed. Third is the discovery phase, which we've identified as the most labor-intensive. Fourth is the mediation phase. In 2026, many U.S. states now mandate mediation before a case can proceed to trial. While mediation is designed to save money, it still involves significant attorney time for preparation and attendance, often costing between $3,000 and $7,000 per session when factoring in both the mediator's fee and the attorney's hourly rates. If mediation fails, the case enters the trial preparation phase. This is the financial danger zone. Statistics show that less than 5% of divorce cases actually go to a full trial, yet the threat of a trial drives the majority of billable activity in the final months of a case. Trial prep involves witness preparation, exhibit labeling, and trial briefs. For a 3-day trial, an attorney might spend 60 hours in preparation. For Mark, that represents $24,000 in fees before he even steps foot in the courtroom. This brings us to a critical realization about the divorce attorney industry. It is a system built on the billable hour, which inherently creates a potential outcome where the duration of the conflict is directly proportional to the revenue of the firm. While most attorneys adhere to strict ethical guidelines, the structural incentives of the industry favor complexity over simplicity. This is why we are seeing a massive surge in alternative models. In 2026, Flat-fee limited-scope representation grew by 12% year-over-year, as consumers sought to cap their exposure to the billable hour trap. But what happens when the money isn't there? What about the millions of Americans who fall into the justice gap? These are individuals who earn too much to qualify for legal aid, but not enough to afford a $5,000 retainer. This demographic is fueling a new subsector of the industry, the legal tech provider. These companies offer automated platforms that guide users through the filing process for a fraction of the cost of a traditional attorney. However, the statistical failure rate of DIY divorces remains high, with roughly 30% of self-filed cases requiring future legal intervention to fix errors in the original decree. The math of divorce is a delicate balance of asset value, emotional volatility, and legal procedure. We have explored how the hours are tracked and where the money goes, but we haven't yet looked at the darker side of the data. There is a specific type of legal strategy, often called papering the opposition, that can be used to intentionally drain a spouse's resources. In the next part of this deep dive, we are going to look at the statistics behind predatory litigation tactics, how much they actually cost to execute, and the specific states where no-fault laws are being challenged by new legislative trends that could change the financial stakes of every marriage in America. If you think the billable hour is the only way costs escalate, wait until you see how the law itself can be used as a financial weapon. While the billable hour is the engine of the industry, there is a secondary mechanism that often drives costs into the stratosphere: the weaponization of legal procedure. In 2026, we are seeing a statistically significant rise in a tactic known within the industry as papering the opposition. This isn't just about filing paperwork. It is a calculated financial strategy designed to exhaust the other party's retainer and mental resolve. Imagine a character named Sarah. Sarah is in a relatively standard divorce in Texas. Her spouse's attorney begins filing a barrage of motions, requests for temporary orders, motions for psychological evaluations, and demands for 10 years of digital records, even if many of these aren't strictly necessary for the final outcome. For every motion filed against her, Sarah's attorney must spend time reading, researching, and drafting a response. If Sarah's attorney bills at $350 per hour, responding to a single frivolous motion can easily cost her $1,500 to $2,000. Statistical trends from 2025 suggest that in high-conflict cases, as much as 30% of total legal fees are spent on what experts call defensive lawyering, responding to procedural maneuvers that have little to do with the actual division of assets. This creates a potential outcome where the spouse with deeper pockets can effectively price the other person out of a fair settlement. Beyond procedural tactics, the very foundation of how Americans end marriages is currently under a legislative microscope. For over 50 years, no-fault divorce has been the standard across all 50 states, allowing couples to cite irreconcilable differences without proving wrongdoing like adultery or abuse. However, as of early 2026, several states including Texas, Nebraska, and Louisiana have seen legislative proposals aimed at overturning or severely limiting no-fault laws. From a statistical standpoint, the elimination of no-fault divorce would fundamentally reshape the divorce attorney industry's revenue model. Historical trends show that prior to no-fault laws, proving fault required significantly more litigation. If a spouse has to prove adultery to get a divorce, they often need to hire private investigators, depose witnesses, and present forensic evidence in court. Case studies from the pre-no-fault era, and current fault-based options in some states, show that these cases can be 50 to 100% more expensive than no-fault proceedings. For the legal industry, a return to fault-based systems could represent a massive surge in billable hours, as every divorce would essentially require a mini-trial on the couple's conduct during the marriage. This legislative shift is sparking a heated debate about gray divorce and domestic safety. Proponents of no-fault divorce point to data showing that its introduction led to a 30% decline in domestic violence and a significant reduction in female suicide rates. On the other hand, critics argue that making divorce too easy has undermined the financial stability of the American family unit. For a divorce attorney in 2026, these shifting laws mean that the advice they give in one state may be completely obsolete just a few miles away across a state line. Let's look at the financial impact of another rising trend: the waiting period trap. As of 2026, 35 states have mandatory cooling-off periods. In some states like Arkansas, you might have to live separately and apart for a full 18 months before a judge will sign your decree. During this time, the legal status of the marriage is in limbo. Attorneys often have to draft temporary orders to cover mortgage payments, health insurance, and child custody during this gap year. Statistically, every additional month a case remains open increases the final bill by an average of $800 to $1,200 in maintenance-level legal fees. For a couple stuck in an 18-month waiting period, that is nearly $20,000 in waiting costs alone, regardless of whether they are actively fighting. In 2026, we are also seeing the emergence of discovery abuse in the digital age. In a modern U.S. divorce, your digital footprint is often the most expensive asset to litigate. Attorneys are now routinely requesting mirror images of hard drives and full histories of social media accounts. The cost of a digital forensic expert can range from $3,000 to $10,000 just to perform the initial sweep. If an attorney finds one suspicious Venmo transaction from 3 years ago, they might spend 5 hours deposing the recipient of that money. At $400 per hour, that single Venmo search costs the client $2,000 in attorney time plus the expert's fee. This highlights a growing disparity in the American legal system. While the person filing for divorce is statistically 42% more likely to have legal representation, the respondent, the person being sued, only has counsel in about 23% of cases. This representation gap creates a massive power imbalance. When one side is armed with a professional papering strategy and the other is self-represented, the potential outcomes are rarely equitable. The industry is currently grappling with how to handle this, as 72% of all family law cases in 2026 now involve at least one self-represented party. Step by step, the industry is moving toward a more adversarial environment in some states and a more automated one in others. If you are in a state that still favors no fault, your attorney is likely focusing on asset valuation and mediation. But if you are in a state where the legislature is pushing back, your attorney is likely gearing up for a more traditional, high-conflict litigation style that looks more like a 1950s courtroom drama than a modern mediation. We have explored the billable hour, the procedural weapons of the trade, and the legislative shifts that could double the cost of getting a divorce overnight. But there is one factor that is more volatile than any law or any attorney's hourly rate: the valuation of a modern life. In the next part of this deep dive, we are going to look at the appraisal war. From the nightmare of valuing a 2026-era social media influencer's personal brand, to the complexity of dividing a cryptocurrency portfolio that is fluctuating by 10% every hour, we are going to see how the hidden assets of the modern world are creating a gold mine for forensic accountants and a financial trap for the couples paying them. If you think your bank statement is the only thing they'll look at, you're only seeing 10% of the picture. While the billable hour is the engine of the industry, there is a secondary mechanism that often drives costs into the stratosphere: the weaponization of legal procedure. In 2026, we are seeing a statistically significant rise in a tactic known within the industry as papering the opposition. This isn't just about filing paperwork. It is a calculated financial strategy designed to exhaust the other party's retainer and mental resolve. Imagine a character named Sarah. Sarah is in a relatively standard divorce in Texas. Her spouse's attorney begins filing a barrage of motions, requests for temporary orders, motions for psychological evaluations, and demands for 10 years of digital records, even if many of these aren't strictly necessary for the final outcome. For every motion filed against her, Sarah's attorney must spend time reading, researching, and drafting a response. If Sarah's attorney bills at $350 per hour, responding to a single frivolous motion can easily cost her $1,500 to $2,000. Statistical trends from 2025 suggest that in high-conflict cases, as much as 30% of total legal fees are spent on what experts call defensive lawyering, responding to procedural maneuvers that have little to do with the actual division of assets. This creates a potential outcome where the spouse with deeper pockets can effectively price the other person out of a fair settlement. Beyond procedural tactics, the very foundation of how Americans end marriages is currently under a legislative microscope. For over 50 years, no-fault divorce has been the standard across all 50 states, allowing couples to cite irreconcilable differences without proving wrongdoing like adultery or abuse. However, as of early 2026, several states including Texas, Nebraska, and Louisiana have seen legislative proposals aimed at overturning or severely limiting no-fault laws. From a statistical standpoint, the elimination of no-fault divorce would fundamentally reshape the divorce attorney industry's revenue model. Historical trends show that prior to no-fault laws, proving fault required significantly more litigation. If a spouse has to prove adultery to get a divorce, they often need to hire private investigators, depose witnesses, and present forensic evidence in court. Case studies from the pre-no-fault era and current fault-based options in some states show that these cases can be 50 to 100% more expensive than no-fault proceedings. For the legal industry, a return to fault-based systems could represent a massive surge in billable hours, as every divorce would essentially require a mini-trial on the couple's conduct during the marriage. This legislative shift is sparking a heated debate about gray divorce and domestic safety. Proponents of no-fault divorce point to data showing that its introduction led to a 30% decline in domestic violence and a significant reduction in female suicide rates. On the other hand, critics argue that making divorce too easy has undermined the financial stability of the American family unit. For a divorce attorney in 2026, these shifting laws mean that the advice they give in one state may be completely obsolete just a few miles away across a state line. Let's look at the financial impact of another rising trend: the waiting period trap. As of 2026, 35 states have mandatory cooling-off periods. In some states like Arkansas, you might have to live separately and apart for a full 18 months before a judge will sign your decree. During this time, the legal status of the marriage is in limbo. Attorneys often have to draft temporary orders to cover mortgage payments, health insurance, and child custody during this gap year. Statistically, every additional month a case remains open increases the final bill by an average of $800 to $1,200 in maintenance-level legal fees. For a couple stuck in an 18-month waiting period, that is nearly $20,000 in waiting costs alone, regardless of whether they are actively fighting. In 2026, we are also seeing the emergence of discovery abuse in the digital age. In a modern U.S. divorce, your digital footprint is often the most expensive asset to litigate. Attorneys are now routinely requesting mirror images of hard drives and full histories of social media accounts. The cost of a digital forensic expert can range from $3,000 to $10,000 just to perform the initial sweep. If an attorney finds one suspicious Venmo transaction from 3 years ago, they might spend 5 hours deposing the recipient of that money. At $400 per hour, that single Venmo search costs the client $2,000 in attorney time plus the expert's fee. This highlights a growing disparity in the American legal system. While the person filing for divorce is statistically 42% more likely to have legal representation, the respondent, the person being sued, only has counsel in about 23% of cases. This representation gap creates a massive power imbalance. When one side is armed with a professional papering strategy and the other is self-represented, the potential outcomes are rarely equitable. The industry is currently grappling with how to handle this, as 72% of all family law cases in 2026 now involve at least one self-represented party. Step by step, the industry is moving toward a more adversarial environment in some states and a more automated one in others. If you are in a state that still favors no fault, your attorney is likely focusing on asset valuation and mediation. But if you are in a state where the legislature is pushing back, your attorney is likely gearing up for a more traditional, high-conflict litigation style that looks more like a 1950s courtroom drama than a modern mediation. We have explored the billable hour, the procedural weapons of the trade, and the legislative shifts that could double the cost of getting a divorce overnight. But there is one factor that is more volatile than any law or any attorney's hourly rate: the valuation of a modern life. In the next part of this deep dive, we are going to look at the appraisal war. From the nightmare of valuing a 2026-era social media influencer's personal brand, to the complexity of dividing a cryptocurrency portfolio that is fluctuating by 10% every hour, we are going to see how the hidden assets of the modern world are creating a gold mine for forensic accountants and a financial trap for the couples paying them. If you think your bank statement is the only thing they'll look at, you're only seeing 10% of the picture. The battle over what constitutes an asset in 2026 has moved far beyond the driveway and the white picket fence. We are now entering the era of the intangible valuation war, a specialized sector of the divorce attorney industry that has seen a 15% increase in billable hours over the last 24 months. When a couple splits today, the most contentious items on the balance sheet are often invisible. We are talking about intellectual property, digital influence, and the speculative value of decentralized finance. To understand the statistical weight of these assets, let us look at a case study involving a character named Jason, a software developer in California whose primary marital asset isn't a house, but a suite of proprietary code and a burgeoning YouTube presence. In Jason's case, the divorce attorney doesn't just hire a real estate appraiser. They hire a forensic digital valuator. This is a professional who analyzes historical trends in ad revenue, sponsorship growth, and the lifetime value of a subscriber base. In 2026, the average cost for a comprehensive valuation of a digital brand or a small tech startup ranges from $10,000 to $35,000. If the spouse claims a community property interest in the future earnings of that brand, the legal complexity doubles. Attorneys must now argue over goodwill, the value of a business's reputation, and its ability to generate future income. Statistically, cases involving business valuations take 40% longer to resolve than those involving only liquid assets, creating a potential outcome where the legal fees consume a massive chunk of the very business being valued. Then we have the volatility of the crypto divorce. In 2026, it is estimated that nearly 20% of U.S. households hold some form of digital currency or NFT assets. For a divorce attorney, this represents a forensic nightmare. Imagine if Jason had invested $50,000 of marital funds into a volatile altcoin during the marriage. By the time the petition is filed, that asset might be worth $200,000. By the time they reach mediation 6 months later, it could be worth $30,000. Historical trends show that courts struggle with valuation dates. Should the asset be valued at the date of separation, the date of the trial, or somewhere in between? Each day of price fluctuation provides a new reason for an attorney to file a motion to reconsider, adding thousands in hourly fees to the tally. Step by step, the forensic process for uncovering hidden crypto is exhaustive. It starts with a subpoena of centralized exchanges, like Coinbase or Kraken. If the assets are in cold storage, meaning on a physical thumb drive or a private wallet, the attorney might need to hire a blockchain forensic analyst. These specialists bill at rates often exceeding $500 per hour. They look for outbound transfers from the couple's joint bank accounts to unknown digital addresses. In 2026, the success rate for finding undisclosed digital assets has improved due to better AI-driven tracking software, but the cost of that search often eats up the recovery. Let's look at the lifestyle analysis. A specific statistical tool used by divorce attorneys to prove a spouse is underreporting their income. This is particularly common in the gig economy or with high-earning freelancers. If a spouse claims they only make $60,000 a year, but their Instagram feed shows them on 3 international vacations and driving a leased luxury vehicle, the attorney performs a net worth method audit. They calculate every penny spent on housing, food, and entertainment over a 3-year period. If the total spending is $150,000 a year, but the reported income is $60,000, the court may impute income to that spouse. This means the judge treats them as if they earn $150,000 for the purposes of calculating alimony and child support. The cost for a forensic accountant to perform this lifestyle analysis? Usually between $7,500 and $15,000. We also have to consider the tax trap. In the United States, the 2017 Tax Cuts and Jobs Act fundamentally changed the industry by making alimony payments no longer tax-deductible for the payer and no longer taxable income for the receiver. By 2026, the long-term statistical impact of this change has become clear. It has made reaching settlements significantly harder. Historically, the tax deduction acted as a subsidy that made higher alimony payments more palatable for the high earner. Without it, the gap between what one person wants to pay and what the other needs to receive has widened by approximately 20 to 30%. This gap is filled with more hours of negotiation, more mediation sessions, and more expert testimony. Now, imagine a scenario involving a professional degree valuation. In certain states like New York, the law historically viewed a professional license, like a medical or law degree, as a marital asset if it was obtained during the marriage. While many states have moved away from this, the concept of enhanced earning capacity remains a massive litigation point in 2026. If one spouse worked a low-paying job to put the other through medical school, the attorney for the supporting spouse will argue for a reimbursement alimony or a larger share of the marital estate to compensate for the investment in the other person's career. Calculating the present value of 30 years of future surgeons' earnings is a statistical exercise that requires actuarial experts. Each side will hire their own actuary, and they will almost certainly produce different numbers, leading to a battle of the experts in open court. The battle of the experts is perhaps the most lucrative part of the industry for third-party consultants. In a high-asset U.S. divorce, It is not uncommon for the expert witness fees to rival the attorney fees. If a case goes to trial, these experts must be paid for their preparation time, their travel, and their door-to-door time in the courtroom. At $500 per hour, a single day of expert testimony can cost a client $4,000. When you have 4 experts testifying, the trial burn rate can exceed $20,000 per day. This data paints a picture of an industry where the cost of finding the truth is often higher than the value of the truth itself. In 2026, the most successful divorce attorneys are those who can act as financial project managers, knowing when to stop the search for hidden assets because the rate of return on the legal fees has turned negative. But for many clients, the emotional need for vindication overrides financial logic, leading them to spend $50,000 to find $40,000. We've deconstructed the billable hour, the procedural weapons, the legislative shifts, and the nightmare of modern asset valuation. We've seen how digital brands and crypto have turned a simple split into a high-stakes forensic audit. But there is one area where the data becomes even more complex, and the stakes become infinitely higher. It's the one area of the industry where the business of divorce collides with the future of the next generation. In the next part of this deep dive, we are going to look at the custody algorithm. We will analyze the statistical rise of 50-50 default laws across the U.S., the $100 billion child support collection system, and how the parenting coordinator has become the newest high-cost player in the family law game. If you thought the money was the hardest part to divide, you haven't seen the data on the kids. When we transition from the division of bank accounts to the division of a child schedule, the divorce attorney industry enters its most complex and emotionally charged phase. In 2026, the traditional tug-of-war over custody is being replaced by what insiders call the custody algorithm. This is a framework dictated by a massive shift in state legislation and the professionalization of co-parenting. We are no longer just looking at a judge's intuition. We are looking at a system of rebuttable presumptions and high-cost neutral experts that can turn a custody dispute into a financial black hole. As of April 2026, the legislative landscape in the U.S. is undergoing a revolution. Mississippi, for instance, just saw lawmakers approve a bill that makes 50-50 joint custody the legal standard for divorce cases, joining a small but growing group of states like Kentucky and West Virginia. This shift fundamentally changes the attorney's strategy. Imagine a character named Emily, a mother in Mississippi filing for divorce in July 2026. Under the old system, Emily's attorney might have focused on proving she was the primary caregiver to secure majority time. Under the new law, the court starts with the assumption that equal time is the best interest of the child. For the legal industry, this hasn't necessarily lowered costs. It has simply moved the goalposts. Now, instead of fighting for more time, attorneys are paid to rebut the presumption. To rebut a 50-50 presumption, an attorney must present a preponderance of evidence, showing it is more likely than not that equal time would be detrimental to the child. This is where the expensive experts enter the frame. In 2026, a comprehensive custody evaluation has become a standard, albeit high-cost, tool. A court-appointed mental health professional performs an investigation that generally takes at least 2 months. They conduct home visits, interview teachers and doctors, and may even require psychological testing for both parents. In a high-conflict case, these evaluations can cost anywhere from $5,000 to over $15,000, often split between the parents but sometimes allocated to one party based on income. Beyond the evaluator, we have the rise of the guardian ad litem, or GAL. In 2026, a GAL is an attorney or a mental health professional appointed to represent the best interests of the child, not the parents. Statistical data from 2025 and 2026 shows that GAL retainers typically range from $2,500 to $10,000. The GAL bills at an hourly rate, often similar to the parents' own attorneys, for every minute they spend investigating the family dynamic. For Emily, if the GAL spends 20 hours interviewing the children's pediatricians, reviewing school records, and drafting a recommendation to the court, that is another $8,000 added to the total litigation cost. Because the court often views the GAL as its eyes and ears, their recommendation carries immense weight, making them one of the most powerful and expensive players in the room. Once the schedule is set, the industry focuses on the child support math. In 2026, 41 states, plus territories like Guam and the Virgin Islands, utilize the income shares model. This model is based on the concept that a child should receive the same proportion of parental income they would have received if the parents still lived together. The math is precise. The state takes the combined income of both parents, calculates a basic support obligation from a standardized table, and then divides that obligation based on each parent's percentage of the total income. For example, if the combined monthly income is $10,000 and the state table says the support for 2 children is $2,000, a parent earning $6,000, 60%, would be responsible for $1,200 of that obligation. However, the 2026 quadrennial reviews, a federally mandated process where states must update their guidelines every 4 years, are introducing new variables. Many states are now adjusting these tables to account for the rising cost of post-pandemic housing and healthcare. In states like Illinois, these 2026 updates are designed to ensure support orders reflect current economic realities. For divorce attorneys, these updates trigger a wave of modification filings. When the math changes, thousands of parents return to court to adjust their existing orders, creating a recurring revenue stream for family law firms that can last until the child turns 18. Then there is the post-divorce management phase, dominated by the parenting coordinator, or PC. A PC is a neutral third party, often an attorney or psychologist, appointed to help parents resolve daily disputes without running back to a judge. In 2026, PCs have become the mini-judges of the family law world. They deal with the small ball issues. Can Timmy play travel baseball? Is it okay if the kids are 10 minutes late for a swap? While they cannot change the overall custody schedule or child support amounts, they have the authority to make binding decisions on extracurriculars, medical care, and scheduling tweaks. From a statistical standpoint, the parenting coordinator is a fascinating economic anomaly. While they are designed to save parents money by avoiding court hearings, they bill at rates ranging from $150 to $500 per hour. If Emily and her ex-spouse spend 2 hours arguing with a PC over which summer camp the children should attend, they have just spent $800 to decide on a $400 camp. Yet, in high-conflict scenarios, the PC is often the only thing preventing a total breakdown of the parenting plan. By 2026, many U.S. jurisdictions are making PCs a mandatory part of any high-conflict decree, essentially embedding a billable professional into the family's life for years to come. We are also seeing the emergence of geography-based litigation in 2026. Proposed laws like Colorado's PEACE Act, Parental Equality and Child Empowerment Act, would codify 50-50 custody but with a specific catch. The presumption only applies if both parents live within 25 miles of a reasonable geographic location, such as the child's school. This creates a new legal battlefront. Relocation. If one parent wants to move 30 miles away for a better job, the attorney must now litigate the 25-mile threshold. This data-driven approach to custody is turning the American suburbs into a grid of billable legal boundaries. The custody algorithm of 2026 is a machine designed for precision, but fueled by the high-cost labor of specialized professionals. We've seen how 50-50 laws are changing the game, how gals and evaluators act as the system's high-price censors, and how the PC manages the long-term friction. We have deconstructed the math of the children, but we haven't touched the final and often most controversial financial